were 9 witnesses summoned to appear by video link before the court in the Ruto and Sang trial.
On the 17th of April 2014, the trial chamber 5A granted by majority the prosecutor's request to summons 8 witnesses to appear before the chamber in the Ruto and Sang trial. And on the 19th of June, the chamber similarly granted the prosecution request to add 1 additional witness. These are prosecution witnesses who decided not to cooperate or were no longer willing to testify. The judges requested the government of Kenya to assist in serving the summonses to the witnesses and to facilitate their appearance by video link for testimony before the chamber. The chamber considered that the prosecutor's request was justified. First, because the witnesses' anticipated testimonies are potentially necessary for the determination of the truth. And second, because a summons, which is a compulsory measure to ensure their appearance before the chamber, was necessary to obtain these testimonies of the witnesses. While the decision to summons the witnesses is currently subject to an appeal before the ICC appeal chamber, the appeal chamber had rejected the defense's request for suspensive effect. That means that the testimonies will go ahead for the time being, and the appeal chamber will decide on the defense appeal in due course. The first witness, summoned to appear, started his testimony on the 4th of September 2014 through video link made possible by a digital connection from a location in Kenya.
Can previous statements of the witnesses who recanted their testimony be admitted as evidence and considered by the judges when they decide on the guilt or innocence of the accused?
Previous statements of witnesses who recanted or changed their testimonies may be admitted as evidence only by the decision of the chamber. Judges may authorize the admission of previous statements if they consider that the admission is necessary to better assess the credibility of the witness, or to put any discrepancies with the witness's oral testimony in the right context, or as well as evidence for the truth of their content based on the criteria of relevance, reliability, and probative value. When making the final determination on the truthfulness of these statements, the judges will take into consideration several factors, including, for example, the existence of other evidence which corroborates these statements.
Why was witness 0604 declared hostile, and what does it mean?
Throughout the proceedings at the International Criminal Court, as is the case at the national courts, parties and participants can call witnesses. Witnesses can therefore be called by the prosecution, the defense, the legal representative of victims, or the judges. All witnesses, regardless of who calls them, are witnesses of the court and are called so that the judges can establish the truth about the events and the role of the accused. Witness 0604 was initially called by the prosecutor. However, at the prosecutor's request and having heard the submissions of the parties and participants, Trial Chamber 5A decided to declare him a hostile or an adverse witness. In their decision, the judges stated that this ruling is without prejudice to the Chamber's ultimate determination regarding the truthfulness of the testimony of this witness. This means that the ruling has no consequence on the judge's opinion of whether or not the witness is telling the truth. The evaluation of this matter will be done at a later stage and in light of the other evidence and testimonies available to the judges. As witness 0604 gave his testimony, the chamber noted the extensive degree to which his testimony diverged from the statement he originally provided to the prosecution. And under these circumstances, the chamber concluded that it was appropriate to permit the prosecution to proceed to explore discrepancies by cross-examining the witness. The judges have discretion to manage the conduct of the proceedings and the mode of questioning in a fair and expeditious manner. By declaring a witness hostile or adverse, the judges allow the party which called the witness initially to cross-examine him. It means that the office of the prosecutor in this case can challenge the witness's credibility. It also means that he can be asked leading questions in order to explore the circumstances of his changed account and the reasons for it.
What is direct examination and what are leading questions?
Direct examination, or examination in chief, is performed by the party that called the witness, and during which leading questions, suggesting the answers or challenging his testimony, are not appropriate. Questions should be formulated in a neutral manner. However, when judges declare the witness as hostile, the party who initially called the witness can ask leading or closed questions. These are questions formulated such in a way that they suggest an answer or invite only a yes or no response. This leading questions technique, as well as the challenges to the credibility of the witness, are normally only performed by the party who is cross-examining the witness and not the party that called the witness, unless the judges declare the witness hostile or adverse or otherwise permit such questioning.